Florida e-discovery project. And today we have a webinar that we're presenting along with the Florida Bar Trial Lawyers section on an important new Supreme Court case that's come down, League of Women Voters v. Detzner. I'm pleased to have with me a colleague of mine, Ralph Artigler. Judge Artigler is a former Florida Circuit Court judge for many years. Before that, he was a distinguished trial lawyer, and now he is a maven, if you will, of electronic discovery, travels the nation teaching lawyers and judges especially about e-discovery. So I'm very happy to have you with me today, Ralph. Thanks for joining me on this important webinar.
Well, thanks for including me in the webinar, Bill. I want to say that Bill and I have been colleagues for a long time. Bill was a commercial lawyer, commercial litigator, and did e-discovery work for 30 years. And now he's at University of Florida. And I really need to thank you, Bill, for not only being my colleague and co-writing with me on things, but also for providing for lawyers and judges quality education from the University of Florida. So there are a lot of exciting things going on there, and so I appreciate that very much. I think that this program's an ideal example of how we're going to provide good information for lawyers.
Okay, Ralph. Well, with that, let's get started. Do you want to begin the discussion for us today? And
sure.
Talk a little bit about what's on the agenda for this next hour, because I know our audience have just an hour. We want to have some quick takeaways here. In other words, what do they need to know about Detzner? Why do they need to know it? And how is it going to affect their practice going forward?
Okay. Well, we all know that lawyers are the classic and the ultimate consumers and users of information. The information has to be found, understood, digested, and employed in our role of achieving justice. And when you and I started years ago as lawyers, that meant looking at paper, finding fixed objects, finding information that would be employed and put before a judge or a jury. But the landscape in which this information that's out there is mined for the purposes of shedding light on the truth has undergone fundamental transformation for all of us lawyers, as it has for other people and organizations and the government and everyone else. The availability of information has exploded and continues to do so in ways that we now know, in ways we can only imagine in the future. And this evolving landscape presents certain knotty issues for the courts, and as we will explain, harnessing that information in the legal context is the responsibility of counsel, because it may not be intuitive to clients on what their responsibilities are with regard to the information that they have and the information that they may want to apply or not want to apply in the course of a case. It's going to be up to the lawyer to explain the law and also the practicalities of preservation of the evidence, which is our topic today. The law of preservation of evidence, as well as its corollary, the provision for remedies against spoliation, has actually been with us for many decades in Florida. The policy behind preservation invokes the fundamental interest of a party to have access to the information needed to pursue a cause of action. And cases in Florida traditionally involved objects like ladders or bottles, medical records, and a myriad of other tangible items. And it was in the context of destruction or loss of these items, which folks thought were significant to their case, that the law of preservation emerged and developed as a common law concept. Actually, with the advent of the digital era, preservation has taken on added significance, because electronically stored information, or ESI as we call it, we'll refer to it as ESI for short, has characteristics that make it potentially ephemeral or easily altered or destroyed, either intentionally or carelessly or inadvertently. From a judge's perspective, and this is something that we work on in the judicial colleges, we have a balanced perspective, and we view the digital media and records and the culture of information as it exists today as an enormously beneficial opportunity to provide relevant evidence bearing on the truth and therefore justice. Lawyers should deal with it that way for their client as well. They need to be able to access this information. And there are more ways to create and modify and store and exchange information than ever before. And there are also many more ways to authenticate or validate the information that's out there, assuming that it's preserved. The metadata, for example, and the myriad of locations where information resides are both ways to validate or press the truth or trustworthiness of information. And therefore, in order to do that, that evidence has to be preserved, and it may have to be preserved in different locations. So preservation has emerged in cases involving ESI and devices, and it primarily has emerged in federal court because they're sort of the leaders in e-discovery and electronic evidence, and they also have a lot more opinions because the district court judges and their magistrate judges write opinions on evidentiary issues. So we'll talk about some of the federal cases that have emerged on preservation, but it's also emerged in Florida courts, starting with a case of Eugene Strasser versus Bose Yalamanchi back in 2001, which involved the destruction of a hard drive. So this law of preservation is something that has evolved both in federal and in Florida courts. And today we're going to discuss a remarkable case that has a specific issue involving preservation, and we're going to try to focus on the trigger of preservation, or when the duty to preserve arises when a case is filed. So that's basically the scope of where we're going.
Yeah, if I could just add a gloss to that, Ralph.
Sure.
What's very interesting about the preservation problem is it's really a duty that we lawyers owe to the court as officers of the court. We can't look at this necessarily in the context of, well, if the other side doesn't request it, I don't have to produce it, and this is part of the adversarial battle, and maybe later it won't bother me and I'll take some risk. That's an antiquated way of looking at it, and wrong from the start. The case law is pretty clear now that the duty to preserve evidence goes to the integrity of the judicial process. And that means it devolves upon attorneys and our duty to the court, not merely as a participant in this litigation process, which we use to try and ferret out the truth. So as part of the table setting exercises here, let's keep in mind that this is something that goes to the integrity of the judicial process, which I think is why the Supreme Court took its time in the case we're going to discuss, League of Women Voters v. Detzner, to talk about preservation, and really courts take it very seriously. I'm a longtime litigator, and I'm very keenly aware that judges don't like it when you're not playing well with data and well with evidence. It doesn't work well. So let's set the terminology. Let's do some basic language here that we want to talk about. Can you lead us through preservation and spoliation, Judge Arthur?
Sure. Well, these, as I mentioned before, are corollaries of each other. Now, preservation is the process of retaining documents and ESI, including metadata, for legal purposes. And just by virtue of the term, it's an affirmative responsibility. Spoliation is the destruction of documents or ESI, including metadata that may be relevant to ongoing or anticipated litigation, government investigation, or audit. Now, spoliation was traditionally a term that involved sanctions, or what's going to happen to you as a result of doing these things. But obviously, spoliation can be an intentional destruction. It can be an alteration that's negligent as well, and it can be preservation. The failure to preserve can be totally unconscious. For example, when a system routinely turns over its documents through a routine destruction process. So all of these different things show the interplay between the two. And when you talk about a duty to preserve, if you fail to preserve, you fail in that duty, then that can be considered spoliation.
All right, well, let's take a look at just a couple of federal cases that have talked about this that are most often cited. And I do want to tell our audience we're going to put our email addresses up at the end of this webinar, and we'd be very happy to send a copy of the slides to you. So don't be too overwhelmed about taking notes on this. We'll have it available for you. Just send either Judge Archicler or myself an email, and we'll be happy to provide you with a copy of the presentation today. First case is Victor Stanley v. Creative Pipe. Ralph, do you wanted to jump in there?
Well, I wanted to also mention, and you can show the other two cases too, because we're not going to spend a lot of time on what federal law is of spoliation, but we also refer you to the article in the current Bar Journal, which discusses this particular case in which this webinar is based, which has a lot of the citations we're going to talk about here. Now, the thing about the federal courts, their range of remedies or sanctions, and we're only talking about the remedies or sanctions as a backdrop or as some of the context for what we're going to talk about later. But the range of remedies or sanctions in federal court will depend on the culpability or intent and the amount of prejudice. And the federal courts have actually differed, and we've showed you three cases here which show the range or difference on the level of intent required before sanctions are warranted in different federal courts. And again, these are most often cited cases. But when we turn to Florida, Florida courts has their own common law on sanctions and spoliation, and you should know that there's interestingly a move afoot to amend the Florida rules on discovery, on e-discovery sanctions. The federal rules were just amended in December of 2015, and Federal Rule 37E on sanctions was changed for electronically stored information, and the federal courts are trying to go to a more remedial range for sanctions for destruction of ESI. And interestingly, our Rule 1.380 on discovery sanctions in Florida is up for potential amendment. They're trying to determine whether they should change to the federal rule. And if you have an interest in that, and procedure wonks like me are going to be involved in it, but if you have an interest in that, you should find out what's going on in your Civil Rules Committee and chime in if you feel it's necessary to do so. But the details on the sanctions rules and the spoliation case law obviously are beyond the scope of a 1-hour program when we're trying to talk about the trigger. But let's just briefly go over the potential range of sanctions that you can have for spoliation or loss of evidence. One thing that the judge can do, and again, this is sort of in the remedial mode that they have in federal court, which is a judge can order more discovery to try to make up for the discovery that was lost. Another potential sanction is cost shifting. If additional or more burdensome discovery required in order to deal with the fact that you've lost this important evidence, may not be crucial, it may just be important and it's going to cost you more, then the party that lost the evidence may have to pay for it. Then we have the two things, adverse inference and presumption, which are the two Florida and federal approaches to, and we normally think of them in terms of the jury, where the judge would instruct them, but also would apply, as we found out in the Detzner case, where the circuit judge inferred improper intent based on the loss of evidence. So these are two, like I said, Florida and federal things. But while we're on adverse inference and presumption, it is important to note that the jury instructions on these remedies, Florida Standard Jury Instruction 301.11, have actually been amended effective April 21st, 2016. So that's new. So if you want to see what the adverse inference or presumption instructions would be, that's where you go to get it. That's 301.11. The other possible sanctions are case ending or issue ending sanctions, and these are among the most significant of sanctions, and obviously the last resort for the court on loss of evidence. You try to do the other less stringent things before you get to the case or issue ending sanctions. And then finally, you can have punitive measures against a party or attorney. And this goes back to what you were talking about earlier, Bill, that this has to do with the integrity of the court process. And if somebody's thwarting that process, there are options for punitive measures. And the example that I most often cite is a Virginia case, Allied Concrete versus Lester, where an attorney and client were both sanctioned with severe monetary sanctions when the client, the attorney actually told the client to take down their Facebook page. And so that loss of evidence or failure to preserve after the trigger had been occurred resulted in monetary sanctions and very significant sanctions for the lawyer and the client. But also the Virginia lawyer's license was subsequently taken away in that case. So these are basically the range of sanctions that you can have.
All right. Well, Judge Article, let's kind of sum up quickly where we are, because we're going to move now into the trigger. But essentially on sanctions, what the courts are looking at is a couple of things. The degree of prejudice that's been experienced by one of the parties as a result of a spoliation. And secondly, the courts are going to look at the intent behind it, whether there was good faith, whether there was a reasonable effort to preserve information, or whether there was some kind of intent to deprive the opposition of the use of the lost information. So it's a little bit of a sliding scale. It's been codified more rigorously in the new federal rule, but all judges are looking at it from a perspective, I think, of what's the least I can do to kind of level the playing field as a result of this discovery mistake. And it runs from very elementary sanctions, which are never felt as elementary when you're on the receiving end, all the way to more dramatic sanctions, which can include case dispositive sanctions in the most extreme cases. So let's move from there to talk about the trigger of discovery. When is it that we have to begin these preservation activities? What's the common law say about this? What's the majority common law view, Judge Articler?
Well, the majority common law view is reasonable anticipation of litigation, and that's obviously a subjective determination. It's a determination that's made on a case-by-case basis on whether not only was it reasonable to anticipate litigation, but they'll also judge on good faith and reasonableness the scope of what you felt you had to save. Now, this is actually federal court and most other jurisdictions. I would say the vast majority of other jurisdictions hold this common law view. Now, Florida, on the other hand, had a common law view that was a little less clear. In Florida, the common law was that you had a duty to preserve if you had a statutory obligation, and I'm going to expand that a little bit, or there was a contractual obligation, or you had a discovery request, which meant the suit had already been filed. In Florida, the question of whether you had a duty to preserve on reasonable anticipation was a lot less clear. As far as the statutory duty is concerned, that would be any legal duty. I mean, statutory is the term that had been used But if you had a regulation, I would assume it would be the same thing. Or administrative rule would have been the same thing. The contract, obviously, that's where you agree with someone to keep something, and then you don't do it, and then when you lose it, they get to take you to task for it. The properly served discovery request after a lawsuit has been filed, that's self-explanatory. Now, other cases, like the Hediger case, said that you had a duty to preserve if the defendant could have reasonably foreseen the claim, which sounds exactly like the federal standard. The question that arose, or the conflict that arose in the cases, was that how does that square with the other cases that say properly served discovery request after a lawsuit has been filed? How would that be an element of triggering of preservation if you could do it on reasonable anticipation? So those cases were unclear, and I think a lot of this has to do with the way cases come. You know, the cases may be particularly or the result may be particularly severe in a given case, and the court may go in a different direction with it than the formalities required. The other interesting thing about this, and all these cases are cited and actually discussed in our article in the Bar Journal, you could have two different standards in the same circuit. It's not like there was a split of authority where you could say in the third and the fourth or the second you had this, and then another circuit you had something different. Within the same circuit, one court would say very strictly the duty can only arise by contract, statute, or properly served discovery request, and then in another case say it reasonably foresee the claim. So this presented a problem. It presented a problem in Florida court, where the courts were dealing with these varying standards, and it also presented a problem in federal court. And there are actually federal court, district court cases in Florida where they're trying to apply the Florida preservation trigger, and they're having difficulty figuring out what it is because of the fact that we had this issue.
Judge Artigler presented problems for the judiciary in figuring out what the applicable law was, but it wreaked havoc for practitioners. We're dealing with clients. We have to advise them as to when we have to begin to do the preservation activities. Is there a pre-litigation trigger? Is the trigger brought when the case is initiated? Can we wait for a request to produce in order to begin the preservation activities? And the key here that was so punishing was that preservation is not something that it's a switch that you turn on and off. It requires a lot of work. We're going to talk about that a little bit later in this article. But preservation is not something that's easily done. It requires a significant investigation by the attorney and the client. It requires a lot of work. So there's a lot of pressure, I think, in many ways, to push the trigger for preservation back in the litigation as far as possible from the client's point of view. Of course, then you run into the position that, sometimes you ought to have preserved information because it can help your case, not necessarily hurt your case. So it wasn't exactly clear as to whether this was something that benefited the plaintiffs or benefited the defendant. And from the plaintiff's perspective, we think about this from a defendant point of view as to reasonably anticipated. We look at that in the context of, when am I going to be sued? When do I know the suit is coming down the pike, if you will? But it also created huge problems for plaintiffs. When in the plaintiff preparation process, is it the case that we need to start preserving information that our client has that's relevant to the case? Is it when the client first knocks on my door and says, I may have some litigation? Is it the point where the attorney comes to a conclusion that I do have a case here, and I'm going to start working on it and preparing documents for the filing of it. Does it occur only at the point when the case is actually filed, or even later than that? So this presented conundrums for practitioners that had significant cost implications as well as result implications.
And Bill, that it also presented an issue for us. Bill and I write a book for LexisNexis and the Florida Bar called Florida E-Discovery and Evidence, and we were left with what do we tell folks on what their obligations are as far as preservation are concerned. And one of the factors that both of us considered important was the fact that you didn't know whether your case was going to be in federal or state court. So if you're going to err, you're going to err on the side of preserving, because you may end up in federal court where they had a reasonable anticipation standard. In addition to that, you had some Florida cases that obviously said that you had reasonably foresee the claim. So that's the side that we came down on, and that book is updated every year. So we did address Detzner when it came down. It was a relief to us to have this clarity, and I know it's a relief to the rest of the lawyers as well. Let's go back to that slide, Bill, if we can, because I want to talk about the Osmulski case. This was a perfect example of the conflicting issues for a court that had to address this. This was a second DCA case involving video on a personal injury matter. And the Osmulski court discussed the law and basically came down on the side that, well, in Florida, you have to have a contract, statute, or properly served discovery request. So this video was destroyed before litigation started, and we're not going to hold the defendant liable for the loss of that video. But they said if the plaintiff had submitted a request even before litigation to preserve the evidence, then they should have probably preserved it. Now that obviously is dicta, but it showed the conflicting, and it's based on the policy behind this of trying to make sure that parties have what they need for a case. So that's where we stand. Osmulski was really the last, I guess, clear case struggling with this before Detzner.
Okay, so then we come to Detzner, and Detzner is a case of League of Women Voters. It's a large case. It's 100 pages, and what it involved is the apportionment of districts within the state of Florida, and whether the shaping of the districts had been done according to constitutional standards. It was addressed by the Supreme Court. It was a momentous decision of very significant political implications, which I think is why the Supreme Court worked hard on it to come up with a result. A lot of people have paid a lot of attention to the result because it had a big impact on the elections that just took place in many districts. However, less attention was paid to what happened in the trial court below, and that's really, from an e-discovery point of view, a fascinating point of view. The legislature, the trial court found, was anticipated, or should have anticipated, that litigation about this was going to take place. It's been a hot litigation topic. You didn't have to have a crystal ball or be guessing to know that this was going to go to a trial court. The apportionment was going to be challenged. And what the trial court found was, notwithstanding that general awareness by everybody, that knowledge that litigation about this was reasonably foreseeable, the legislature made no attempt to preserve the emails that underlied their discussions about why this was happening and what the underlying motivations and reasoning was for the apportionment that was taking place. The court said, based upon these facts and circumstances, I'm going to draw an adverse inference. I'm going to assume this information was not favorable to the legislature. And that became an important part of the trial court's decision. the Supreme Court took that on, and I forget exact the pages. It's like pages 86 to 91 approximately. Maybe you got them.
On the actual published view, it's page 390 to 392, which is right in the middle of this long opinion.
Right. They basically said, look, the trial court was correct in the way it approached the case and the way it analyzed the impact of the loss of the state and what it was going to do about it. So what did the Supreme Court ultimately say, Judge Artegler?
Well, the Supreme Court ultimately affirmed what Judge Terry Lewis, a friend of mine, very, very fine trial judge, did in this particular case. I mean, basically what Judge Lewis was faced with, the legislature preserved a number of records relating to the redistricting, but the documents were all benign. They showed the time and location of public meetings and other benign details, and they destroyed communications among the legislators, communications between the legislators and the staff, and they also between the legislators and the consultants that were helping them with this supposedly fair redistricting process. So Judge Lewis felt that this was extremely important information, and the Supreme Court looked at what Judge Lewis did and said, well, we agree with Judge Lewis that there was no rule or requirement, no statute that required them to keep this. So, and the court uses an interesting term. They said there was no legal duty to preserve the evidence, which by that I presume they mean something other than reasonable anticipation of litigation. And they did, however, say that based on the Hedegar case, that there was a duty to preserve the evidence because the legislature should have reasonably foreseen the litigation. And so they affirmed Judge Lewis's inference of improper legislative intent. Judge Lewis was trying to determine the intent of the legislature in this particular circumstance and whether it was appropriate intent on the redistricting or not. So that, as far as I'm concerned, changed the whole landscape of instability by making it a stable future for us as far as determining these things, because it basically says that Florida courts, I mean, this is the quote is right here, Florida courts have in any event found a duty to preserve evidence in other circumstances when a party should reasonably foresee litigation. So what this means is that if you have a statutory duty, if you have a contractual duty, if you have a discovery request, or if you should have reasonably foreseen litigation, all of these things now are in play in triggering the duty to preserve.
Yeah, George Artegler, you're correct. You know, our position in our book was that this was what each attorney should do in handling litigation. But now we've got it clarified by the Supreme Court, and in some respects, it's a little bit of a be careful what you ask for because you might get it one way or the other. What we have now is a clear articulation of what the standard is in the state of Florida. Parties should preserve evidence when litigation is reasonably foreseeable. But this is going to have some implications. This is going to impact how we practice. And these implications are not de minimis. It's going to raise the bar, if you will, on practicing litigators and how they have to approach preservation duties in their case. Can you take us through a couple of these implications?
Sure. I mean, first of all, whether a duty has been triggered or not is going to be a threshold determination for the court. It's just like Judge Lewis did, the court's going to have to weigh the various circumstances, and it's going to vary on a case-by-case basis. Now, this determination is going to be based on the policy behind the preservation of evidence. So you're going to look at basically, why would you need to preserve this evidence, and what importance does it have for the case? And the courts are going to look to try to determine their cases on their merits and not have a case turn on the failure to do something procedurally in discovery. However, if what you failed to do in discovery had an impact on the result of the case, then they'll fall on the side of this policy of preservation and a remedy. And again, we discussed what the remedies would be. They're going to be a sliding scale. It'll depend on the circumstances of the case. Now, interestingly, the availability of relevant evidence has to be proportionate to a case. And Florida has always had proportionality as a backstop, I guess, to discovery. In other words, you don't have to keep everything. It's just not reasonable to ask you to do that. And in federal court, the new 2015 rules have moved proportionality to the prominence of a scope of discovery issue. In Florida, it's always been, well, since 2012 when we had new discovery rules, it's been in Rule 1.280, which is scope of discovery. So we actually had a rule that was in advance of what the federal courts did, which usually the other way around. So proportionality is going to be a consideration in what you preserve in a case. It's going to be a consideration what you ultimately have to produce in the course of a case. And you may preserve more than you actually have to produce for a case. So I think that this is a backstop and an important one to take into account.
Well, Judge Archegler, I got to tell you from the practitioner's point of view, I still got a lot of heartburn. We're coming out of an environment in Florida and state court practice, which is a little different than federal court practice, where at least one proportionality was built into Rule 26, and now it's been moved up to 26B1, so it's front and center for federal judges. And I think that even some of the federal judges are expressing a little bit of surprise as to what is going to mean. I have been practicing in Florida for 30 years, find judges still are looking at the scope of discoveries being bound by the classic expression of, is this information capable of leading to the discovery of admissible evidence? And that's kind of been the definition of relevance. So, I think this may be a spur, Detzner, to moving the Rules Committee forward a little more quickly to make sure we do get proportionality front and center in Florida. But it's going to create some tension for attorneys out there that are looking at judges that have typically a very broad perspective on discovery and relevance. And now we have litigation preservation taking place when litigation is reasonably anticipated. So let's talk a little bit about the implications of that, if you will,
Sure.
for practicing attorneys.
Well, let's run it back to that last slide while we're still talking about proportionality, because I want to I guess give a little bit of relief to your heartburn in the sense that now that the federal rules have moved proportionality to a scope of discovery issue, then the Florida rules and the federal rules are on very similar footing. And that is going to open up a whole library of information about proportionality that lawyers can use in determining what to do in different circumstances, because there are more cases that are published in federal court. I'm trying to encourage circuit judges here in Florida to publish their opinions as well on these scope of discovery issues, because it's going to be important to us. But the advantage of having rules that are similar in Florida and federal law, both the common law rules and the rules of procedure, is that it will assist you to look in those federal cases and see if you find something that's similar to your facts, and the judge may find it persuasive. And I think that I teach around the country. I've just just did a couple of weeks ago. I had 4 federal judges from around the country talking about this proportionality issue, and they are taking it seriously because the cost of litigation is such a significant factor that keeping it in check and keeping discovery in check is a feature that is taken very seriously. But let's go ahead and talk about some specific examples, because that'll probably help.
Okay, but I just do want to touch on one point you mentioned, which it's a specious argument that I think we should alert the judiciary and attorneys to that are watching this webinar. Some attorneys, in an attempt to represent their clients, are going to argue that, look, we don't have proportionality in Florida because we don't have the same rule that the federal courts have. Therefore, the language of our rules is different, and if we wanted to have proportionality, the rules could be changed to accommodate that. They haven't been changed. Therefore, we're still back in the old broad relevance perspective. I think that's the wrong argument. I think it fails for all the reasons that you mentioned, Judge Artiglaire, but I think we can all see it coming down the pike. I urge attorneys not to utilize it because it's wrong, and I urge judges not to give it credence additionally because it's wrong. Okay, let's go next to speaking of lawyers. What's going to be the role of lawyer in preservation now?
Well, obviously, the lawyer is going to have a duty, and this is what I alluded to at the beginning of the presentation. The client is not going to be the one who knows that her emails happen to be offloaded by her iPhone onto her husband's laptop. I mean, those are the kinds of questions that you or people that you have helping you are going to have to raise with the client, so you can find all of the locations there are. The lawyer's going to be the one who's going to know when preservation is triggered. The lawyer's going to be the one to know what the scope of the preservation has to be. And the ABA specifically changed their model rules of professional responsibility in 2012 to say that lawyers have to be up on technology. So I think that that's something we've had in Florida. We had actually ethics opinions that said that for a number of years before the federal ABA, or not federal, the ABA rules were changed. But the trend now is that lawyers are taking on the onus of having to understand those things. Now, if you look at Florida Professional Ethics Opinion 14-1, and we'll discuss that a little bit more later in this program, it specifically talks about how you would deal with social media preservation issues. In California, in 2015, they came up with an ethical opinion that basically tells a lawyer how to handle a case soup to nuts, an e-discovery case, which is, to me, unheard of and ethical. Right? Nobody told me when I was doing medical malpractice work how I handled a malpractice surgery case, but they're telling us in ethical opinions now, or at least in California. And the more that we get away from actually following through on this duty and responsibility, the more we can find that ethical issues are going to step in.
Yeah, I think there's no escape now from lawyers questioning, discussing, and going through checklists as to what kinds of data locations their clients have. We live in this ecosphere, this bubble of electronically stored information that surrounds us. Lawyers have to go through a checklist about it. We have a checklist on our text that's available. There's others out on the web and the internet. Make sure you have a checklist that you, when you're going through with your client and you decided a trigger has been reached, that list all the potential sources, because you're going to miss them. Look, they fly planes with checklists. If a pilot can use a checklist to make sure the plane's going to fly well, we should be sure to use a checklist to make sure our discovery is going to go well, because I guarantee you, if you don't use a checklist, nobody can remember the 20 or 30 different locations of electronically stored information. And here's the real thing. Relevance is a legal determination. We go to law school for years. We spend a lot of time with our students here at the University of Florida talking about what's relevant evidence. evidence for the purposes of preservation. So that's a judgment. You just can't leave that to the client. And if you do, there's always a chance that some court is going to ask you to account for that. So please, let's make sure that we take on our duties to do that early on in the case, as soon as we realize under Detzner now that we've got a pre-litigation duty to preserve. Let's take a look at what the impact of this will be for the requesting party, Judge Artiglaire. Any recommendations?
First of all, the value of a written request for the preservation of evidence. We saw in the Osmolsky case that the court, while it was dicta and is now overridden by the fact that Detzner has sort of washed over that and required anticipation of litigation, it's still valuable to send a written request for the preservation of evidence. Number one, if let's say, for example, your opposing party is unsophisticated and maybe even not represented by counsel, the fact that you send a written request for preservation of evidence should put them on notice that you expect that preservation occur, and should be a factor for the court to consider on the reasonableness and good faith on whether preservation has occurred. It tells them, I mean, you don't have to think then in terms of is litigation reasonably anticipated. You've told them that litigation is anticipated. So that's important. It can also help shape the scope of preservation that's required. If there's a lawyer on the other side, or like I said, a client, either sophisticated or unsophisticated, by sending a written request for the preservation of evidence, you can at least start a dialogue on what the scope of that preservation may be. And frankly, someone on the other side may not even think of some things that you feel should be preserved. And you may have an expert, or you may have a client that has enough understanding about it that you can identify things that should be preserved. And rather than leaving that to chance, you put it in a written request for the preservation of evidence.
Okay, well, let's be clear about two things about that. First of all,
sure.
Don't anybody think that I haven't gotten a letter from the other side, therefore the trigger hasn't
right.
been. You've got an independent duty to assess whether litigation's reasonably anticipated. So let's make sure that we don't rely upon that as some kind of excuse down the road. It may help. It may be part of an argument that a court will entertain, but it doesn't eliminate your duty and your responsibility to engage in that kind of analysis. So,
Bill, I think one of the common sense things to do is, if there's something that's crucial evidence, let's say, for example, you have a personal injury on a premises. There's no reason that a video of what occurred would not be crucial evidence on what occurred. So you should ask them to preserve it. A lot of these things are on loops, and they get overwritten. So you go out there and make that request. I mean, there are things that are no-brainers, and then there are things that are going to be more sophisticated. But you can't assume that your client is going to know these things, or that the opposing party is going to know these things, or even the opposing party's attorney.
Yeah, and of course, what's good for the goose is good for the gander. There's a mutuality issue here. So if you're telling the other side, for example, if you're a plaintiff's counsel and you're dealing with a slip and fall case, and you're sending a letter notifying potential defendants, well, that of course means you have the duty to work with your client to preserve the information on your end. Now, it may not be enough as much. There may be a kind of asymmetric discovery here, but the duty devolves upon you as well. So don't think it's just a one-way street here. This is a two-way street, and there have been many cases in which plaintiffs' cases have been thrown out of court or have been damaged significantly by a failure to preserve relevant evidence. This really takes place in, for example, in medical malpractice cases as well. The the provider may receive a letter. Now, of course, once you receive a letter, that doesn't mean that, of course, you do have that a trigger has occurred. It's a big indicator of it. I'd be very hesitant if I ever received a letter not to engage in pre-litigation preservation, but I can imagine some extreme circumstances where it's a joke or a quack or some other kind of fool has written a letter. But for the most part, you've got to take those very seriously.
Okay.
Let's talk about the producing party's perspective, which is typically we look at it from the perspective of the party that has thinks they may be sued down the road. What do they have to do, Judge Archibald?
Well, I think we need to continue with the idea that normally the lawyer will know more than the client about the legal duty to preserve, and the client will know more about what information they have, what their system is, and so forth. So the attorney and client have to work together to achieve preservation. I think that the federal courts in a number of years ago, lawyers in a case found out from Judge Shira Shinlin in the Southern District of New York that they can't just tell the client to preserve and just let it unfold and not supervise the process. The case is the Zubalake case or Zubalake 5. There were a whole series of them, but in which the term Zubalake duty came up, which meant that an attorney must make sure that that the preservation is occurring, not just tell the client to do it. Now, there are cases all over the map in federal court, and I think you can't be simplistic about any of these things, and that probably, it's not an outlier, but that's one side of the equation on what the responsibilities are. But I think that if the court doesn't hold you accountable for the matter of not telling the client what needs to be done, the client may hold you accountable, because you may, as you said before, you may lose something, the client may lose something they need for their case, or they may lose something that ends up being a sanction against them. So it behooves the attorney and the client to work together to achieve preservation. And you start with a litigation hold letter or memorandum, which reflects what your advice is to the client with regard to this.
Let's talk about a couple kinds of situations that might give rise to a trigger. Reasonable anticipation. We've talked a lot about one, and that's receiving a letter from the opposition. That's typically a trigger. The other kind of a trigger might be prior events of a similar nature that have led to litigation. For example, in the employment context, this comes to mind. If it's the case that companies experiencing litigation following certain kinds of events, such as reduction in force or terminations, or other events that raise emotional qualities, it may be very prudent to think, look, at this point, we have a reasonable anticipation that person X may come and sue us for wrongful termination. So we got to look at the context and see whether the context gives rise to whether litigation is reasonably anticipated or not. Courts have held clients and lawyers to that particular standard. Another indicia that's been used broadly is whether other parties have been sued similarly. For example, if it's a case that there's been a series of patent litigation, and one company after another has been sued for a violation of a particular patent, and you're using that patent, and it may be foreseeable at that point that you're next in line, or at least further down the line, of those that are going to be sued for violation of the patent for infringement. So that may be a situation also where litigation will be deemed by a court to be reasonably anticipated. So these, and the gravity of the accident or the gravity of the expense, of course. For example, in a typical contract business environment, there's lots of bumps on the road. People yell at one another all the time. There's all kinds of claims that you didn't honor your contract or this product's not great. But at a certain point, we all know that the dispute has reached a level of acrimony that typically leads downstream to litigation. So we have to be aware of that. Now, this creates huge problems for counsel, for general counsel, and for retained counsel, because what we have to do is educate managers downstream to be aware of these kinds of circumstances and bubble that up to the general counsel's office so that the general counsel or the president of the company, speaking with outside counsel, can be aware that these events are taking place within the company that are now perceived to be likely to lead to litigation. So not only is this a problem that attorneys have to face in dealing with general counsel or presidents of corporations, it's a problem that the entire company has to be thinking about in terms of when litigation might be reasonably anticipated.
And Bill, I'd like to at this point mention the Sedona conference because I teach with them. You teach with them. They're a tremendous resource. It's a nonpartisan think tank out of Sedona, Arizona, and all you have to do is put the Sedona conference in your web browser, and you can see what I'm talking about. They have materials. That they have a jumpstart outline on how to deal with e-discovery cases. They have e-discovery principles, and they have information on legal holds and so forth that would be extremely, and preservation would be helpful. And obviously, we have our book, which deals with Florida in particular, but with those materials, I think you could get a pretty good scope. I do want to talk about social media a little bit because fortunately in Florida, there's an opinion for that. I mentioned this earlier, Florida Ethics Opinion 14-1. And this came out of that case I referred to out of Virginia, in which the lawyer and the client were sanctioned for taking down a Facebook page. And the Judicial Ethics Committee for the Florida Bar, not judicial, the ethics committee for the Florida Bar were smart enough and prescient enough to come up with some guidelines for lawyers in which they take the trial lawyer step by step on the do's and don'ts in advising a client. So for example, if you have a personal injury client and you ask them if they have Facebook, and you look on the Facebook page, and there's something that is not good for your particular case. This ethics opinion actually tells you what you can do in safely preserving the evidence, and obviously you don't need to leave it up there, according to this opinion, for all the world to see if it's not a good thing to be there. But there's a way to preserve it and take care of it. So I would commend that to all of you. If you haven't read that ethics opinion, it's important to have that. Now, if you just think that's personal injury lawyers, it's not true. Social media, it cuts across everything. Family law, in particular, businesses have social media as well. So that opinion is extremely important in avoiding spoliation and in encouraging preservation and showing you how to do it.
Yeah, family law is a good example of, I think, the implications of Detzner in terms of when preservation has to take place, because it presents very knotty emotional and personal problems. Again, suppose you're an attorney and you're approached by an individual who may want a consultation regarding whether divorce is appropriate or not. Does that create a trigger, that mere consultation? Or perhaps it moves to the next phase where the client says, I really need to look into this, and what are the chances that I'll obtain child custody, and what's the range of custody, and what can I expect of alimony or rehabilitative alimony? And you start doing research on that. It seems to me now you're running into a very dangerous area in terms of preservation. At that point, it may be the case that the litigation might be deemed to be reasonably anticipated if you're doing research on this topic and marking it attorney work product. So, and then clearly, if you get to the point where you start preparing papers for divorce and for child custody or separation, at that point, it seems to me clearly the trigger has emerged, and then that raises the whole issue of social media and identifying the social media locations and the many sites that are out there. Going through a detailed checklist, as we talked about before, is absolutely critical. Beyond the scope of this webinar is how you do that, which is another tricky wicket, if you will. But we've got methods for that and techniques. The important point, though, for us right now to know is that it's clearly established in Florida law that the duty to preserve relevant evidence arises when litigation is reasonably anticipated. Judge Artigler, do you have any concluding remarks for us?
Yeah, I think that now that we have Detzner, the law is clearer, but the onus remains on counsel to make sure the client gets the job done and that relevant and proportional evidence is preserved. You're the one who knows the legal process. You're the guide for the client through that process, so it's your responsibility. And because reasonable anticipation of litigation is a patently legal determination, it's going to be made by a judge, clients will inevitably need guidance and understanding on what that duty means on that, and also the scope of the preservation that's going to occur. And I commend everybody to take a look at the article if you haven't looked at it, because it talks about even more than we discussed today.
That's our article. That's currently the lead article in the November Florida Bar Journal. If you have any questions, please don't hesitate to contact me or Ralph Artigler about the themes or topics of this webinar. We thank you very much for joining us, and please stay tuned. We'll be bringing you more webinars on important e-discovery issues as they're emerging in the state of Florida. Thank you very much.
Thanks, Bill.
Thank you, Ralph.